A package of controversial wetland regulations advanced by state environmental regulators were dealt a setback earlier this month, with a trial court judge finding the Hochul administration did not follow the letter of the law in their regulatory process. The fate of the regulations is up in the air, as the case could potentially make its way through the judiciary's appeals process, but in the short term, the decision is being declared a victory by the state's business interests, who were primarily concerned with the outcome of the regulations and not necessarily the process. For more on this story, we're joined on the Capitol Press Room by Roger Downs, Conservation Director of the Sierra Club Atlantic Chapter. Welcome back to the show, Roger.
Thank you for having us, David.
And we're also going to hear from Drew Gamils, a senior attorney with Riverkeeper. Thanks for making the time, Drew.
Thank you very much for having me.
Glad to have you here. So for starters, for those listeners who aren't developers or businesses that have been following this issue since the state's freshwater wetland law was updated in 2022, what are the officials at the State Department of Environmental Conservation trying to accomplish with the regulations they put out last year?
The legislature and Governor Hochul passed sweeping reforms to the Freshwater Wetlands Act in 2022. This is a law and regulations that have been around for 50 years. And after a long public process, implemented a final regulatory program that went into effect in the beginning of 2025. Under the old program, DEC had permitting authority over wetlands 12.4 acres and larger, but only had jurisdiction over wetlands that found their way onto approved paper maps. And that system was woefully incomplete and vulnerable to political suppression of map amendments. The new law did away with the jurisdictional nature of maps and created a better digital information map system and gave DEC the authority to protect wetlands if they met the basic definition of wetlands, which is a criteria of vegetation and certain soils, which is similar to the way that the Army Corps of Engineers has identified jurisdictional wetlands for decades. The new law also allowed for DEC to require permits for activities affecting smaller wetlands that possess unusual or important qualities like contributing to flood control, significant to protecting water quality, or providing habitat for endangered species like rare amphibians and vernal pools. It was the first time vernal pools were granted this kind of protection. The new reforms were purported to expand regulatory authority over 1 million additional acres of wetlands in New York, but clearly there was backlash from the business community. I will say 4 separate lawsuits were filed last year challenging the new wetland regulations by petitioners representing local governments, trade groups, business interests, and landowners. In these 4 cases, which were eventually consolidated, petitioners raised a range of claims, including that the rules were unconstitutionally vague, arbitrary and capricious, and infringed upon home rule principles. The good news for us is that the court rejected all these claims and upheld the validity of the law and the regulations in terms of the construction and content. But the bad news for us is that Albany County Supreme Court Justice Richard Platkin annulled the Part 664 wetlands regulations in their entirety for non-compliance with the State Environmental Quality Review Act.
Well, Drew, turning to you, let me highlight what the judge said here. Essentially, they found that the Hochul administration didn't comply with the New York Environmental Quality Review Act, which Roger mentioned in crafting these wetland regulations, finding that there wasn't an examination of reasonably foreseeable environmental consequences. Does that square with your understanding of the process, or do you think state regulators took into account the potential for urban sprawl and the impact on aquatic ecosystems, which the judge says was not done in this case?
Yeah, so as you pointed out, the judge focused his decision in annulling the regulations only on the fact that DEC did not comply with the State Environmental Quality Review Act. And he said that they didn't adequately identify the relevant areas of environmental concern, that they didn't take the required hard look, but DEC did do the forms. They went through the process, and what the judge is saying is that they didn't have a reasoned elaboration for their negative declaration. So the judge was looking for more information, more detail from DEC about why they were saying that the regulations were not going to have a significant environmental impact. DEC went through the process. They followed the necessary steps. It's just the judge is saying that they didn't elaborate enough.
Yeah, I think the judge felt and I felt somewhat unironically, that the DEC should have taken the environmental concerns of land developers more seriously, that these business interests believe that the enhanced protection of urban wetlands under the new rules would have somehow led to sprawling development in suburbs elsewhere, which I think is unfounded and somewhat convenient for probably the only folks that really do control sprawl. The fact that DEC did not address this issue explicitly in their negative declaration of environmental significance invalidated the entire secret process.
Well, regardless of it, whether it was a good faith critique from the plaintiffs in this case, do you feel like this does potentially suggest there are issues with the state's regulatory process? Because I could imagine a different scenario if things were reversed and maybe DEC was relying on a short form environmental assessment form and their analysis was on very narrow premises, and the rules and regulations maybe didn't go as far as environmentalists wanted, that environmentalists would say, hey, you haven't gone through all the steps. You haven't done A through Z that would necessarily inform your process, and you haven't, after the fact, given us a good explanation of your rationale. So does it matter whether this is a good faith critique? I mean, I would assume that environmentalists would want state environmental regulators to always show their work and go that extra mile.
Yeah, we support the state environmental quality review process. And I think DEC had a lot of materials. They had, taken substantial amount of time to prep these regulations, to issue them. They even did an advance notice of proposed rulemaking to get answers and guidance on certain issues that were later addressed in the regulations. So they really took their time and went through the process. The judge is critiquing specifically that negative declaration, but the materials were there. I mean, DEC did do its homework. And, as an environmental organization, that's what we want to see. We want to see the state environmental quality review process working as it did and, requiring our regulators to take their time and look at these issues. DEC just, in the judge's view, did not put it in the necessary format.
I mean, I think the technical legal expression he used at one point was they did not take a quote unquote hard look. So it doesn't sound like it was just an issue with paperwork. I mean, that seems like a substantive critique.
But certainly, all of us going through the rulemaking process and attending stakeholder hearings, I mean, it's clear to the environmental community, DEC was really listening to the development community and trying their best to balance, what we needed to do to protect wetlands versus the interests of developers, which include certainty. I think the problem here is that a lot of the claims brought by the petitioners are just so laughably, not true environmental concerns. I mean, the judge referenced concerns from the Chautauqua Lake property owners who leveled false accusations that the new regulations would proliferate aquatic weeds, degrade water quality, and impair the lake's ecosystem. And if anything, I think the opposite is true. It's the few remaining wetlands attached to the Chautauqua Lake that are doing the most to stave off harmful algal blooms and maintain water quality. And we saw over the course of the first year of the program, there was a clear pathway for lakeside property owners to get permits to continue weed control, to dredge for boat slips, maintain shorelines, and many of them did obtain those permits. And I think it's an example of where DEC saw no potential environmental harm coming from these new regulations. But again, it didn't occur to them to include a narrative why these were sort of false accusations in their narrative for justifying the negative declaration of significance. And the judge seemed to find these stated fears by the lakeside property owners as legitimate.
So at least initially, the response from the Hochul administration was that they were reviewing the ruling and hadn't decided whether they would appeal. I don't know if there's any update on that in the week since this case was handed down, but do you think the state should appeal this ruling ultimately?
The state's in a tricky situation. It's great news that the judge upheld the 2022 amendments to the Freshwater Wetlands Act, held that they are constitutional, They didn't violate due process. They're not impermissibly vague. So the requirements of protecting wetlands of unusual importance under the 11 criteria, that still stands. That exists. So DEC just no longer has the regulations providing guidance on how that law is going to be implemented. So DEC needs to come up with advice as to how they're going to carry out the 2022 amendments. And so, as you noted, the state has till May 11th to file an appeal. So they have some time, and they need to consider what's their best option. And so they could file the appeal, they could try and obtain a stay, they could forego the appeal and just start, the secret process over again for Part 664 and do a new secret process for the same regulations. They can modify the regulations and do a new secret process. So we have no additional guidance from DEC at this time as to exactly what their plan of action is going to be. They've continued to say that they're taking their time, they're reviewing the decision, but we do know that they're going to have to take some sort of action and issue some guidance so that there's an understanding of how they're going to carry out these 2022 amendments to the Freshwater Wetlands Act.
DEC found themselves in a similar situation a few years ago when the net conservation benefit portion of their threatened and endangered species regulations was declared null and void by a court because the DEC apparently never held requisite public hearings for the proposed changes. But eventually, as a remedy, the DEC initiated a new rulemaking now with public hearings to reinstate the regulatory language. I think in this situation, the ruling is just created so much uncertainty. I mean, we estimate there's about 1,900 freshwater wetlands permits already issued under the program. Are they no longer valid? There's over 10,000 jurisdictional determinations. Members of the public applied to DEC saying, do I have a wetland here or not? And apparently 40% of them resulted. The DEC got back to them and said, yes, you have a wetland here that your development plans will require a permit for. There's still a lot that needs to be determined here.
I think there could be a critique from environmentalists that the Hochul administration has had kind of a schizophrenic take on the environment in the last couple of years. So are you concerned at all that the administration's approach to this issue moving forward might look dramatically different than the way it approached these rules and regulations in the aftermath of adopting this 2022 law?
That is a concern. You always have to have that concern, especially kind of seeing how things are playing out currently. But again, my focus is on the fact that the amendments to the Freshwater Wetlands Act were declared constitutional and they still exist. So there's no reason for the legislature to change the Freshwater Wetlands Act itself. It's really just DEC strategy on the regulations and what they're going to do. So I have hope that we will see DEC continue to move forward, work on its regulations through the State Environmental Quality Review Act, and get something in place so we have clarity on how we can protect these vulnerable habitats and wetland ecosystems.
Well, we've been speaking with Drew Gamils. She's a senior attorney with Riverkeeper. Thanks for making the time, Drew.
My pleasure.
And we've also been hearing from Roger Downs, Conservation Director of the Sierra Club Atlantic Chapter. Thanks as always, Roger.
It's always good to be here, David.
Fraud and lawsuit abuse raise car insurance costs for New Yorkers. Reforms are being proposed to mitigate their impact, but some Albany leaders want to keep the status quo. Information on these reforms is available at keepnewyorkaffordable.org.